Hello viewers, welcome to our lecture series on marketing management, and in this very series we have been talking about Consumer Protection Act 2019 and modern marketing. So continuing my discussion on the very topic, now I will tell you about what is there into this very enactment of Consumer Protection Act 2019. In the previous lecture of mine, I told you about the background, the World Consumer Rights Day, why it is celebrated on this particular day, that is 15th March, and what is the genesis of the Consumer Protection Act 2019. Prior to that there was an enactment of Consumer Protection Act 1986, and now we have got this new enactment, and what are the 6 significant rights of consumers as per this particular enactment. And we also talked about the different terms which were defined under the enactment. So continuing my discussion on the topic, now I will tell you about some more new definitions which are being included under the enactment. And I would like to highlight here that this very new act includes the definition of food, which is also defined under the Food and Standards Act 2006. So for the first time the Consumer Protection Act has included the definition of food also. So food has been defined, and this has replaced the definition of goods under the erstwhile enactment called Consumer Protection Act 1986. Now what kind of benefit we are going to emanate, what kind of benefit we are going to get out of this new definition? This would actually help in bringing the number of food delivery platforms also to come under the ambit of Consumer Protection Act. Earlier they were not included into the definition of Consumer Protection Act, and that is why those food delivery platforms, they were excluded from the ambit of Consumer Protection Act. But now with this new definition, they have also been brought into the ambit of Consumer Protection Act 2019. So this is a welcome step, because when we go for online purchases or online buying, majority of the time or most significantly repeatedly the platforms which we are using is devoted for the food delivery platforms. So we are making use of their services, but as a consumer we were not having any right to claim any kind of losses, or to file any complaint against the food delivery platform, just because of this, that they were not included under the definition of service providers under the Consumer Protection Act 1986. So in order to bring the telecom services also under the new act, telecom has been added to the definition of services. So even the telecom services are now included into the definition of services under the new Consumer Protection Act, which was earlier, otherwise it was not there. Now under this enactment, there is a system of Consumer Protection Council. Now why this Consumer Protection Council or CPC is being formed? In order to promote and protect the right of the consumers, there are certain, this very council is being established under this very enactment. So the purpose of establishing this council, Consumer Protection Council, is not only to promote but also to protect the right of consumers. You are informing your customers about, your consumers about their rights, that is okay, but what about providing protection to them? Simply informing that these are your rights is not going to suffice the purpose. You have to actually protect the right of your consumers. So their scope is not regarding directly dealing with consumer complaints at initial or appropriate scope, but to promote and protect the right of consumers. So this Consumer Protection Council is there to not only promote but also protect the right of consumers in a very efficient and effective manner. Now the question comes, what are the objectives of this particular council under the enactment? So the council under Consumer Protection Act is there to promote and protect the rights of consumers. For instance, the right to be protected. I told you about the certain rights of consumers, the 6 rights we had discussed, and now the same is here as an objective of this very council. Right to be protected against the marketing of goods and services which are hazardous to life and property. If there are certain goods or services which may be hazardous to life and or property of the consumers, then they stand a right to stay protected from that. The second one is the right to be informed, not only about the quality but also the quantity, potency, purity, standard and price of goods or services. whatever the case is, and it is just to protect the consumer against unfair trade practices, what you call as UTP. Said that we have to provide, protect our consumers against unfair trade practices, and for that it is being defined as the core objective of this council, which is being established under the enactment. Then the third one is the right to be assured wherever possible access to a variety of goods and services at competitive prices. Not only variety but also the availability of these products or services at competitive prices. Then comes a right to seek a redressal against unfair trade practices or restrictive trade practices, or what you call as unscrupulous exploitation of consumers. So you have a right to seek redressal. If you have certain grievances, there has to be a forum where as a consumer I can raise my issue and I get a redressal against the unfair trade practices or restrictive trade practices, and that is being listed as the core objective of the council. And the last one is the right to consumer education. Consumer need to be informed about the product, its possible usage, about apart from over and above the cautions that it can be hazardous to certain extent, you need to educate the customers as well. So right to consumer education is another important right which is being listed as the objective of the council. Now there is a Central Consumer Protection Council. The central government has established a council known as a Central Consumer Protection Council. If we wish to understand the enactment, we need to first understand the structure, that what is there at central level, what is there at state level, what is there at district level. So let us start with the central level. We have a Central Consumer Protection Council which is established under this very enactment. The central government has established a council known as a Central Consumer Protection Council. We call it CCPC, and this is also called as a central council, consisting of the minister in charge of the consumer affairs. So whosoever is given the charge of minister under the Ministry of Consumer Affairs in the central government, he or she shall be the chairman of the council, and the such member of other official or non-official members representing such interest, whatever is being prescribed, they are supposed to be the member of that. And there is a condition regarding their meeting, that the central council must meet as and when necessary, and there is a rider here, but at least once in a year. So minimum times for which this council must meet is at least once in a year. So this council can meet as and when the need arises. Otherwise also, even if there is no need, then too they must meet at least once in a year. And this has been made mandatory that they are supposed to meet at least once in a year. This is the role of Central Consumer Protection Council. Now at the state level, we have State Consumer Protection Council. What is the role of State Consumer Protection Council? The State Consumer Protection Council is also being headed by the Minister of State under that particular ministry, and we have to understand that the state government has established a council known as the State Consumer Protection Council. It is called as a State Council, and it will consist of the minister in charge of the consumer affairs in the state government shall be the chairman of the council. So the particular minister in charge of the consumer affairs in the state government, he or she shall be the chairman of the council, and likewise the members such member of other official or non-official members representing such interest as may be prescribed by the state government, they will be forming the part of the council, and these members of other official or non-official members not exceeding 10 as may be nominated by the central government. So the maximum number of members who can be nominated by the central government is 10, that it should not exceed 10. And what is the number of times they are supposed to meet? It is actually twice in a year, that they will also be meeting as and when the need arises. Otherwise also the minimum minimum number of times for which they are supposed to meet is at least twice in a year. So unlike central council where they have a mandate of meeting at least once in a year, at state level it is it is being doubled, and they are being prescribed that they are supposed to meet at least twice in a year. So, central level council is there and state level council is also there. Then comes the district consumer protection council. Now, the state governments, they are supposed to establish a council known as a district consumer protection council. We call it DCPC, and in every district they are supposed to establish these district councils, and they are very much established. And this particular council consists of the collector of the district, or what you call a district magistrate of that particular district shall be the chairman of the council. So, in all districts of our country, the collector of that particular district is going to be the chairman of the council, and again the state government may decide the members who are representing this particular council, such member of other official or non-official members representing such interest as may be prescribed by the state government. So, here the role of state government is very much important as far as district consumer protection council is concerned. And even at the state level, the district collector or the district magistrate is going to be the chairman of this particular council. Now, there is a CCPA, Central Consumer Protection Authority. One of the most significant addition to the Act of 2019, that is Consumer Protection Act 2019, is the establishment of CCPA. And we always it was very much welcomed by the people from people having the legal expertise. It is regarded as one of the most significant addition to the act to establish Central Consumer Protection Authority, and it has certain features which are being listed here. The first feature is that this authority shall consist of a chief commissioner and other commissioners as may be prescribed to be appointed by the central government. So, central government is going to prescribe the name of those chief commissioner and other commissioners to be appointed by the central government, and they will be forming part of this particular council. And this central authority will have an investigation wing also, which is supposed to be headed by a DG, we call it Director General, for the purpose of conducting inquiry or investigating under this act. I'll discuss in detail little later, where I'll tell you that what kind of powers they have. They can take suo motu cognizance of any wrongdoing by a seller, and they can come forward to provide protection to the interest of the consumers. So, the CCPA has to regulate, protect and enforce the interest of the consumers and matters related to unfair trade practices. So, they are going to vehemently work on this, and the CCPA is actually a very robust provision under the Consumer Protection Act 2019. Now, the question comes, what are the powers which are being conferred to the CCPA by the enactment? So, the CCPA has been provided with the vast powers to inquire, to investigate and take action against violation of the enactment of 2019. They have given vast powers for the first time under the Consumer Protection Act to inquire, investigate and take action against the violation of the enactment. Another significant power which is being which has been showered with is the power to take action and impose penalty against misleading and false advertisement, as well as against any endorser of such advertisement. Now, here comes the role of celebrity endorsement. Previously, as far as the celebrity endorsement was concerned, the celebrities, they were not being held responsible for any kind of wrongdoing by the marketers, because they were simply there to basically endorse the product. It was earlier considered as they were considered to be innocent, or they were not considered to have complete information about the product, the service provider or the quality of it, or the advertisement which is being floated, which is being communicated to the consumers. So, here the CCPA has been given the significant power to take action and impose penalty against not only the misleading and false advertisement by the company, but also against the endorser of such advertisement. So, the act of celebrity endorsement is now becoming very responsible work now. It is being considered to be a very responsible task now, and that is why most of the celebrities nowadays, they actually first have the complete details, they obtain the complete information about the product, the service provider, and then only they are giving their consent for celebrity endorsement. And this is because of the vast powers which are being conferred, which are being given to the CCPA. And here when we say taking action against celebrity and the company, it means the CCPA can now initiate action against the celebrities who have endorsed such misleading and false advertisement, provided such celebrities fail to carry out any due diligence before participating in such advertisements. So if they have followed due diligence before participating in such advertisements, then of course they are being held responsible. Otherwise, the onus of proving that is actually upon the celebrity who are going to endorse the product. I'll tell you about the celebrity endorsement procedure, which is there in Western countries. They actually follow a Q score approach. There are certain techniques which are being followed for deciding celebrity for a particular product. Although unfortunately in India we don't have any such system. The celebrities, they are being selected on the basis of their popularity, not on the basis of any quantified score like Q score, which is being followed in Western countries. And here you will be surprised to learn that the CCPA may impose a penalty to the tune of rupees 10 lakhs for the violation which is being committed for the first time, and up to rupees 50 lakhs on every subsequent violation, not only on a manufacturer but also on endorser for a false and misleading advertisement. So somehow if a company is found guilty of flashing or floating a false or misleading advertisement, they can be imposed a penalty to the tune of 10 lakh rupees for the first time violation, and subsequently for every subsequent violation it is going to be rupees 50 lakh, and it is not only on a manufacturer but also on endorser. So in addition to this, such manufacturer or endorser may be sentenced to imprisonment for up to 2 years as well. So imagine, the provisions are now stringent. Not only the financial financial penalty is there, that you have to pay some penalty on account of your wrongdoing, but also there can be an imprisonment for up to 2 years. So this is making their task more responsible. They are supposed to act in a more responsible way. Now the question comes, who can file a complaint? Either I should file a complaint as a consumer, or somebody else on my behalf can also file a complaint. This is a very popular question by the consumers, that I'm not that literate, I'm not that legally literate, how can I file a complaint? So a consumer, either individually or jointly, or any voluntary consumer organization or central or state governments, they may file a complaint. So either myself can file a complaint individually, or suppose we are having a group of consumers, we can also file a complaint, or any voluntary consumer organization like an NGO can also file a complaint. Central or state governments, of course, they can file a complaint. And here there is a limitation period of 2 years, that there is a limitation period of 2 years which is there in place, that from the date of cause of action, that is purchase of goods or hiring of services, from the date of purchase till the duration of 2 years you can file a complaint. So after 2 years, that becomes a time barred complaint. You can't file a complaint for a purchase which is made before 2 years. So limitation period is 2 years from the date of cause of action, that is your purchase of goods or hiring of services. Now what is the procedure? So my dear learners, here you will be very happy to note that a very simple written complaint in duplicate with full name and address of opposite party, narrating facts of the complaint along with the copies of supporting documents and details of the relief sought may be submitted. So it is very simple. It is as simple as writing an application. You have to simply write a complaint in 2 copies in duplicate, that is why it is written, and you have to provide your full name and address of yours as well as the opposite party. And the best part is, there is no court fee which is being applied on this, no court fees being charged from the consumers. And even there is no need to engage any lawyer for this particular complaint. Engaging of lawyer is not necessary. Consumer or anyone can represent his or her case. So you as a consumer can also present can be present before the court and narrate your story, narrate your complaint, that yes, this is my problem, this is the problem which I am facing, and this is the complaint. So neither there is any court fee, nor there is any need to engage any lawyer, nor there is any format of filing a complaint, because it is a simple written complaint which you can file. So procedure is being made so simple, and it is very much consumer friendly, I would say, under the enactment. Now the question comes, what are the levels at which complaints may be filed? So there are 3 levels, as we all know, that central level, state level and district level. So let me start with the district commission. Suppose if you are you feel that some of your rights or any of your rights are not being protected, you can file a complaint under the Consumer Protection Act, but you should know that for which amount I should go to which level of the authorities. So district commission is being established by the state government in each district of the state by notification, and district commission have a jurisdiction to entertain complaints where the value of the goods or services paid as consideration does not exceed rupees 1 crore. So if the price which you have paid for that particular product or services is not exceeding rupees 1 crore, you can go to the district commission and file your complaint. So the amount limit is there, that your sale consideration, the price which you have paid for goods and services, if it does not exceed rupees 1 crore, then the right forum for you is district commission. Then comes the state commission. Of course, the level is going to be little higher. So each state commission shall consist of a president and not less than 4 members. Now here the condition is that complaints where the value of goods or services paid as consideration exceeds rupees 1 crore but does not exceed rupees 10 crores. So if you are in the range of more than 1 crore but less than 10 crore or equal to 10 crores. So if it exceeds rupees 1 crore but does not exceed rupees 10 crore, then the right forum for you is to file your complaint is state commission. So state commissions are going to entertain the complaints which is having a value of more than 1 crore but does not exceed rupees 10 crore. Now comes national commission. So national commission shall consist of a president and not less than 4 members. Here also the number of members who are there into the commission is limited to 4 only. And here the as far as the limit is concerned, complaints where the value of goods or services paid as consideration exceeds rupees 10 crores. So anything above 10 crore is going to be taken care by the national commission. So this is the limit which is being prescribed. So we must know as a consumer that at which level we have to file our complaint. And this limit of financial amount is being called as pecuniary jurisdiction. So there are 2 types of jurisdiction, one is territorial, another is pecuniary. So whatever we have discussed up till now, it actually in the legal language we call it pecuniary jurisdiction. So for district commission, if I have to summarize, I would say if your claim amount is up to rupees 1 crore, which means your invoice amount is up to rupees 1 crore, you have to go to district commission and file your complaint. And remember that district commission, if you look at the office structure, they are headed by a president and 2 other members. Wherein at state commission, if your claim amount is exceeding rupees 1 crore but it is up to rupees 10 crore, then the right forum for you is state commission. Again it is headed by president and 4 other members. At national commission, if your claim amount exceeds rupees 10 crore, then you must directly go to the national commission, which is headed by the president and 4 other members. And here the maximum age for president of this particular commission is 70 years and 67 years for other members. So it means there is an upper age limit for the president and other members of this national commission as well. So my dear learners, this is called as pecuniary jurisdiction wherein depending upon the claim amount, we must know that at which forum we are supposed to file our complaint. So if my amount exceeds rupees 10 crore, then I need to file my complaint at National Commission. So if we are aware of the place where to file our complaint, it will save our time and efforts as well. Now when we talk about pecuniary jurisdiction, the new act has also changed the manner for determining the pecuniary jurisdiction for filing the complaint. Now the pecuniary jurisdiction will be determined on the basis of the value of goods or services paid as consideration as against the old act. In old act this was not the provision. This pecuniary jurisdiction is something new which is being mentioned under the new enactment. So what was there in the old act, the pecuniary jurisdiction was determined as per the value of goods and services as well as compensation claimed. So in the old act it was not so. In the old act it was decided on the basis of value of goods and services as well as compensation claimed, wherein under the pecuniary jurisdiction here in the new enactment, it is decided on the basis of the value of goods or services paid as consideration. So they are not looking at compensation which you are claiming, they are looking at only the value of goods or services which we have paid as consideration under the new enactment. So this is something very new into this enactment. Now what is the purpose behind doing so? This is going to help in doing away the practice of inflating the compensation claimed. So earlier, in order to avail the services, people used to escalate the amount of compensation as a consumer, so as to bring the complaint within the jurisdiction of state or national commission. Earlier what people were doing, in order to bring that particular complaint to the jurisdiction of state or national commission, people used to raise their compensation amount, cause at that point of time the pecuniary jurisdiction used to be decided on the basis of value of goods and services as well as compensation claim, which is now not the case. Now it is solely on the basis of consideration which you have paid. So it is making the entire escalation of matters reasonable. Otherwise it used to be lopsided, that at district level the number of complaints used to be very few, and at the state and central level we used to have a huge number of complaints filed. Now apart from this, we do have a provision under this enactment of e-complaints. So that this new act also contains enabling provisions for consumers to file complaints electronically and for hearing and or examining parties through video conferencing as well. This is the biggest relief to the consumers, that earlier consumers used to feel the pinch of filing a complaint and then visiting the court again and again. Now they can go through the hearing and or examining parties through video conferencing as well. And we do have alternate dispute resolution, another provision which is introduced by the new act to ensure speedy resolution of dispute is to provide for referring the dispute to mediation. So even that mediation facility is also provided. So my dear learners, in this way we have gone through certain relevant and key provisions of Consumer Protection Act 2019, and I thought of discussing it on this very day, because 15th March is being celebrated as World Consumers Rights Day. I hope you must have understood the brief nuances of this particular enactment. Some more key provisions of this enactment I will be presenting before you, I will be discussing with you in the next lecture of mine. Thank you so much.